think I was quite shocked the first time I went to an employment tribunal because I'd always been told it was informal and I went and it was pretty formal. But it is made to be accessible because you don't need legal representation to attend the tribunal. So if a former employee or a current employee raises a claim, it's not the type of legal process where they require representation. They can represent themselves. So for that reason, the rules and the format is supposed to be designed so that, that's accessible to a lay person. So we'll just run through a bit about the process now. So the kind of first time as an employer that you would know you're facing an employment tribunal claim is normally when you get the early notification email from ACAS. And I've just listed that. That's the example that ACAS give of what that looks like. And it basically just informs the employer that they've been contacted by an employee or an ex-employee about a potential workplace dispute. So that's the example ACAS give of what that will look like. And it lets you know that's the first stage in the legal process before a claim can go to the employment tribunal. And what that early notification does is it starts a period of what's called early conciliation. And that's facilitated by ACAS, who sits separately to the employment tribunal. It's a separate body, but this early conciliation period is designed to try and avoid workplace disputes ending up in the employment tribunal. So it commences what's called a period of early conciliation that will typically last 6 weeks unless either party ends that early. And during that period, ACAS will act as an intermediary and go between to try and resolve the dispute, check if there's any scope to settle it to avoid it going to tribunal. But this is a voluntary process. But in practice, most employees tend to want ACAS to contact the employer before they raise that claim. And ACAS in general do not give advice to the employee or suggest a resolution. They'll really be that intermediary. They'll be a go-between, but they won't have any influence over the outcome. So an employee, when they raise a claim, they've got 3 months to do so after the last act. So the last act or failure to act, I'm sure is the terminology they use. So that might be from, the last time they were paid wrong or from their dismissal. So it's generally 3 months, but I've put there that that's likely to raise to 6 months soon based on the employment pledges and the employment bill passed by the Labour government. So it's likely that will increase to 6, but right now it is 3. There's some instances where they might use their discretion to extend that 3 months. Most notably if it's a discrimination claim, if the tribunal thinks it's just and equitable to do so, they can raise that to 3 months for the employee to raise the claim to the tribunal. But the clock stops for any period spent in early conciliation. So what we just discussed before, that 6-week period where ACAS is trying to resolve the matter before it goes to tribunal, any time spent in that will be added on to the 3 months. So the 3-month time limit stops the clock for the period of early conciliation so that can take place between the parties. The employee will need the early conciliation certificate before they're able to raise a claim to the tribunal. So at the end of the early conciliation period, ACAS gives them a certificate with a code, and when they actually go on to raise a claim or fill out a claim form, they need that code. So they need to show that they've contacted ACAS about conciliation to be able to physically raise the claim. And what the claimant will fill out is called an ET1 claim form. So if you have a Google at that, you can have a look at what it looks like online. All the forms are on there. But it basically, just asks for the standard details about pay, and then that will have the section on the form where they'll set out the kind of particulars of the specific claim. So normally, where we will assist is responding to a claim. And what will happen is once the claimant puts in that ET1 form, the tribunal will then issue a notice of claim to the employer or ex-employer and a copy of that ET1 claim. form. And in response to that ET1, respondent must complete a ET3 response form, and that's the form that's going to set out your defence and your response to all the claims that the claimants put forth in their claim form. So there's a time limit on that as well, and that's 28 days running from when you get that notice of claim. And that is quite a good fact just to have in your head. If you ever get a notice of claim through with a copy of the ET1, it's not one that you want to sit on, because the 28 days of runs from that being sent to you, sorry, from you receiving that. So if it's sitting unopened, you might open it and only find that you've got a week to gather your defence to the claim. So it's just worth being wary that when you get one, you want to start preparing your defence straight away. If you're represented, your solicitor will submit it via the online My HMCTS system. So if we are dealing with a tribunal response, that is where we will submit it. But it's a new system, it's kind of in its beta phase. So what we say is that the earlier you get all the information over to your representative, the better. Just because it gives them more scope to deal with the new system and its many technical errors. And once you've got your claim and response in, once the employee has a claim in and once you as the employer, ex-employer have your response in, it's then really over to the preparation stage for the final hearing. And in that there's a number of different steps depending on what claim it might be. So the first thing that I've put is preliminary hearings. So not all cases will require a preliminary hearing, only those which are more complex in terms of legal issues, like a discrimination claim. But that is essentially a hearing that needs to take place before the final hearing where the decision is made. And it could be for case management purposes quite often. So you might get a claim, but it's not clear what the legal issues in that claim are. You need further information. So that's something that often takes place at a preliminary hearing. The judge will go through and you'll agree and work out what the legal issues are to be determined at the final hearing. Also at preliminary hearings for case management purposes, normally a dates will be set, a timetable if you will. You sort out things like what witnesses are going to attend, when the documents will be swapped. So all of this can be dealt with at a preliminary hearing. You can also have what's known as a substantive preliminary hearing, and that's where there's some sort of question that needs to be answered by the judge before it can go to final hearing. So a good example of that is, say you have a disability discrimination claim from a ex-employee, but you're disputing their disability status. The Employment Tribunal would need to have a hearing before the final hearing to answer that question of, is this former employee disabled or not? So you have to answer that question in the preliminary hearing before it can move forward to the final hearing. From that, you normally get some case management orders from the employment judge. But even if you don't have a preliminary hearing and it's something more standard like unfair dismissal, you'll normally always get case management orders from the tribunal, and that will just set out a number of dates. It'll be things like swapping documents, having the joint bundle prepared, all of anything that the judge needs will be in your case management orders. So you tend to find that if you're preparing for an employment tribunal case, you'll normally always be working, towards dates and deadlines, and it can be quite a front-loaded process. And obviously, when you have the case management orders, that's really when things will ramp up with your legal representative to start gathering at all the evidence, everything that's relevant to the case. There'll then be a bit of a collaborative process to gather all of that together. So that'll be things for what we call the bundle of documents, which is really just a big file that we'll use at the hearing with all the documentary evidence that will be referred to throughout the hearing. Witness statements is another key part of preparing for tribunal. But what I will say is that it differs slightly from England to Scotland. So for English tribunal cases, witness statements are more standard and they'll normally be ordered by the judge in the case management orders and be exchanged with the other side. So we'll prepare witness statements from all the company witnesses. They'll prepare theirs as the claimant and we'll switch them before the final hearing. That tends not to happen as often in Scotland. In Scotland, it tends to be that our witnesses will give evidence orally. So on the day at the final hearing, they'll go up on the stand, we'll ask them a host of questions, and their answers will form their evidence rather than a pre-prepared statement. So Scotland tends to be oral evidence, and England witness statements written are more common. But there are some cases in Scotland where they will order witness statements if something's, particularly fact heavy and there's, lots and lots of witnesses. They might order witness statements, just for efficiency purposes. Even in Scottish cases, though, I would say we just, in practice as solicitors, will normally still always come out and take witness statements from all the company witnesses. They won't be shown to anyone, we don't swap them, but it's really just for our benefit to have a written statement of what everyone's evidence is, and helpful for them to remember their evidence too. So that's another kind of key part of preparing, speaking to all the witnesses. And once you've gotten through, the preparation, any preliminary hearings, eventually a date will be set for the final hearing. And that can be held by an employment judge who is sitting alone, or for a more complex case at the moment, with two lay panel members. So that's two panel members that are non-legally qualified. They normally have someone with an industry or trade union background and then someone with a HR background just for balance. But again, with current reforms upcoming, it's likely to move to an employment judge only for most claims soon. And as I say, the examination of witnesses will take place at most hearings, final hearings in Scotland. And as I say, that is just question and answer to witnesses on the stand, and the information that they give in response to the questions forms their evidence. They'll also have access to the bundle of documents at the final hearing with all the documentary evidence. So that would normally be referred to through that process at the tribunal. Any witnesses who are on the stand will be subject to cross-examination. So that could be cross-examination by the other side's solicitor if they have one. But if they're not legally represented, it will just be cross-examination from the ex-employee or employee themselves. Sometimes the judge can intervene to help them form questions, or if there's any instances of badgering the witness, anything like that, the judge will help them focus their questions if they're unrepresented. But it's just worth noting that cross-examination isn't always necessarily by a solicitor in the employment tribunal. And once all of the examination, cross-examination, and all the evidence has been given at tribunal, it would then be a case of concluding by giving legal submissions. So that would be where, company solicitor would give submissions to the tribunal, normally summarising all of the evidence, raising any relevant case law and authorities that they think that the tribunal should be compelled by, or they find persuasive in their arguments. And the other side would have the opportunity to do so as well. So that's just a very brief overview of what you could expect to see at a final hearing. So just in light of that kind of quick run through the process, just some top tips that just through the course of being involved in employment tribunal claims, you tend to find help. The first one just being follow your internal policies and procedures. So whether that be a disciplinary policy or an absence policy, you know, being able to bring that policy along as part of the bundle of evidence at a tribunal, and demonstrate that you followed that always helps. Keeping accurate records. So there's just, you know, it can be challenging when you're collating all that documentary evidence for the bundle of documents, which will be at the final hearing, will be referred to, you know, and there's gaps in that, perhaps. You know, maybe there's no minutes of meetings, or you know, some letters are missing. You really want to be able to show a clear timeline of an incident, with any relevant correspondence. So just making sure that when you're doing these kind of internal processes, that your records are accurate. Another one is just to document informal management conversations, because a lot of the time this actually provides really valuable evidence in an employment tribunal. Whether that even be just confirming a conversation you had about performance by email afterwards. All of this can be used in a bundle of evidence at tribunal to show the full picture, and can be really useful evidence. So it's worth a good practice to exercise. And then the last one just being seeking legal advice if it becomes particularly complex. Or, you know, I think you always benefit from legal advice if it's at the stage where it becomes complex. So this is just a very quick run through of the kind of key points of the process, and you know what it looks like from start to finish as an overview. But we actually do a more in-depth workshop, we kind of call it, and we've ran it privately for companies in the past, but we're going to be running it again in March. It's just a half-day session, and dare say it's actually quite fun because it's more interactive. It features a presentation about the employment tribunal process in more depth than what we've done today. But then really the star of the show and the bulk of the day is interactive, watching a mock tribunal, seeing our solicitors actually cross-examine witnesses. We even have Lindsay acting as an employment judge. So it really brings it to life. And as well as that, we've got our own kind of bundle pack so that managers or HR people can get involved before we go to the hearing, and read about the case. Got group activities based on the case. So it's a more in-depth kind of training on the employment tribunal. And as I say, I don't think we've put it out yet or advertised it, but I've popped my email on the slides, which you'll get if you want to register interest. But I'd say it's helpful for anyone with people management responsibilities. So that finishes us up for today. If anyone's got any questions, feel free to fire away. We've got plenty of time left. Well, if we're all good, then that will conclude us for today. Thanks very much. But I'll hang about for a couple of minutes just in case anyone has anything when they're popping off. Thank you.
Thanks, Amie.
That's great, Amie. Thank you.
See you later.